inadmissibility. A foreign national may be inadmissible for immigration to Canada on the grounds of criminality, and those grounds are the following. For convictions of Canada, you must show that you are convicted in Canada of an indictable offense punishable by a sentence of less than 10 years, or you have been convicted in Canada of 2 or more summary offenses. For convictions outside of Canada, you have been convicted of an offense outside of Canada that, if committed in Canada, it would be the equivalent to an indictable offense punishable by a sentence of less than 10 years. Or, if you have been convicted outside of Canada of 2 or more acts that, if committed inside of Canada, would be equivalent to a summary offense. Or, if you have been convicted outside of Canada of 2 or more acts that, if committed in Canada, would be equivalent to a hybrid offense punishable by a sentence of less than 10 years. For criminal acts committed outside of Canada, if you have committed an offense that, if committed in Canada, would be equivalent to an indictable offense punishable by a sentence of less than 10 years. If you are currently charged with or previously convicted of any kind of criminal offense, inside or outside of Canada, you may be prohibited from visiting, working, studying, or applying for permanent residence in Canada. The following examples of convictions can make you inadmissible to Canada: driving under the influence, driving with the ability impaired, theft, petty theft or larceny, also known as shoplifting, assault, disorderly conduct, or obstruction of justice. These factors can make you inadmissible to enter to Canada and prevent you from obtaining the permanent status in Canada. If you have further questions, please call us.